pull it off my docking station, and then it just all went up in flames. So I didn't hear exactly what you, sorry. Hi, Ed, how are you?
Hey, Valerie, how you doing? Good to see you.
So we were talking about questions. I heard the word questions, which freaks me out, but go ahead, say what you said.
Yeah, we'll definitely have a chance to do some questions in the Q&A box, so.
Will they be able to see them?
Once they're answered, yes.
It'll be okay. I see the nervousness.
Okay, so did you say you want to wait till the end? Are you going to do the questions, Kit?
Yes.
Okay.
All right, so Ed, why don't we give it just about another minute? We're up to about 250 odd people to see. It keeps building quickly, so you have a lot of people waiting to get in to hear this.
Oh, and somebody's already sent you a love note, Kit.
Let me see who these are. My fan club. All right, let's see.
So that's an announcement, Kit, you can make from the beginning and just let them know that chat has been disabled, and if they have any questions, they need to put them into chat.
Okay, so did everyone hear that? If you have any questions, you won't be able to do it by chat. You're going to have to go into the Q&A, ask your question, and Ed is going to take those questions, the both of them probably at the end of the class. However, if there's something that's relevant that comes up, I'm going to go ahead and direct that question to Ed. So you will be able to see those answered questions as soon as Ed. Okay, so Jennifer, that has to be on your computer because other people are hearing us. So try and turn up the volume. What else I got here? Kevin, looking forward to getting all the answers. All right, you guys, let's go ahead and get started with this now this morning, actually. I would like to introduce to you Mr. Edward Zorn, who has been a real estate attorney for almost 30 years. He is the Vice President and General Counsel for the California Regional MLS, also known as CRMLS, and he is responsible for all legal aspects from contracting to litigation management. In his role as Vice President, Ed oversees the compliance and licensing departments for CRMLS for over 105,000 brokers and agents. Prior to joining CRMLS, Ed's law practice focused on realtor association, broker, and developer representation. He has been a state director and an ombudsman for the California Association of Realtors. He is still an active member of CAR Legal Affairs Forum, and Ed currently serves on the NAR MLS listing issues and policy committee. And he is a frequent presenter at association and MLS industry events. Thank you, Ed, and we look forward to hearing what's going on. And I'm going to let you take it away.
Great. Thank you. I appreciate that. And thanks for the opportunity to come and join your group here and to share a little bit of things. We're going to be obviously talking about the NAR proposed settlement. I'm going to give you an update and go through some of the rule changes that are happening. So we're going to talk about the settlement, what NAR has done, and then what CRMLS has done as far as implementing some of those policy changes into the actual rules. And then we'll talk about and have an opportunity to take some of your questions. So go ahead and use that Q&A box, get those questions in there, and we'll kind of take those as we go along and definitely have some time at the end. So I'd like to start off with this quote that's very, very relevant for this period of time, which was when Wayne Gretzky was asked, what makes you such a great hockey player? He says, I skate to where the puck is going to be, not where it has been. This is important for you guys to keep in mind as we start to go through what these changes are and how to use them to enhance your business and business opportunities. This is not a death blow to the industry, right? There's lots of opportunity here for those who can see that and embrace that. So I would encourage you to think more about going with the flow and what opportunities are going to be in front of us rather than trying to hold on tightly to the past. So some important dates that are really coming up is, as you guys know, NAR did a settlement agreement on March 15th. And the court preliminary approved that in April, with the final approval coming in November. But the most important date for you guys right now is August 13th. On August 13th, that is the day that CRMLS will be removing the compensation fields from the MLS. And that is the date that we will be having the mandatory buyer representation agreements required to be in place before you show a property. Those are the two big aspects, and we'll go over the details of that. But August 13th is the day that you want to circle for those events happening, right? So, as you know, NAR was involved in these class action lawsuits. NAR fought hard. Guys, these went on for 5 years. Realize the first lawsuit on these commission issues was filed in February of 2019. So NAR fought hard for 5 years. They made the best arguments that they could based on the facts, and they lost. And when you lose at a trial, there are consequences. And so as a result, NAR was really, honestly, guys, facing bankruptcy. And so rather than go down a bankruptcy route and reorganize and really protect only themselves, they went ahead and agreed to resolve the case, pay a substantial amount of money that got a lot of people out of the case, including all the MLSs, all of the associations, all of the realtors, individual agents are all released, as well as all but 94 brokers across the entire country. So very favorable settlement, and they did agree to some practice changes, things that we as the MLS have to do to have that release. And the goal here is for the industry to change how they deal with these commission issues. Okay. So we're going to walk through those policy changes from NAR and the corresponding CRMLS rule. First big one is about buyer agents having to get a written agreement before they tour a buyer through a home or show a property. Now remember, these cases are about steering and the fear of steering, right? The idea here was that agents were going into sellers' living rooms, arguing that if you didn't offer a certain amount of money to the buyer's agent, then those agents wouldn't show the property. Probably not happening in reality, but the fear of that potentially happening is what the allegations were that drove to the loss in the lawsuit. So you're going to see these rules are going to be kind of fashioned around stopping that from happening. And the first way to stop potential steering from happening is making sure that the buyers themselves can negotiate the fee that's going to go to their buyer's agent directly. So instead of the fee that a buyer agent is going to get being decided by some seller and listing agent out there, it's now going to be decided upon by the buyer. And these written agreements are going to have to be specific as to the amount being paid, right? They don't want games being played. And the other key component is when you agree to that fee as a buyer's agent, that's a fee you're going to get, right? You're not going to get more than that. And that's, again, very rational, very reasonable element, right? We're going to be incorporating this NAR policy into the CRMLS Rule 9.1, right? And so here is the actual wording of our rule. And remember, this has to be done as a buyer's agent before you ever open that door to show a property. That's the time frame when this has to occur, okay? And remember, the fee can't be open-ended or whatever the seller's offering or something like that. You have to set your fee before you open that front door. So that's one big important rule. Again, August 13th is the date where we're going to be having this rule go into effect. Next big change with regard to the MLS policies is that the settlement agreement requires us as MLSs to remove any fields that have offers of compensation to buyer brokers and also require that we are not allowed to collect what a listing agent or total amount of broker compensation on a listing. Now, that second item, we've already have a rule against that, and we've never collected that. So that one was easy. What's happening on August 13th is we're going to be removing the fields that you currently have access to, the BAC field, right? The offer of compensation field will no longer be there. This is encapsulated in our rule 7.15, and the rule is broader than just getting rid of that one field. The rule is actually, as a listing agent, you cannot put anywhere in the MLS any offer of compensation from the listing broker or the seller. That means you cannot put it in private remarks. You cannot put an offer of compensation uploaded in some kind of separate document as a supplement. You can't bury some kind of offer of compensation in the property description. Okay, it's just not allowed. We're going to look for it, and we're going to issue some kind of fine if you do it. Okay, so be warned. Don't do it. Right? There's no reason to offer compensation. So, one of the other policy changes.
Ed,
Yes,
can I horn in here for a second?
absolutely.
Okay, so we do have a question, and I think it's important that they have an understanding of the difference between CRMLS and NAR. The question is, since the settlement allows us to not join NAR, can you describe how and why CRMLS is not or is planning to leave NAR?
So the first part of that statement is not accurate. The settlement agreement has nothing to do about joining NAR or not joining NAR. And CRMLS is entirely owned by realtor associations. So the reason that CRMLS follows the National Association of Realtors MLS policy is because our ownership structure is 41 individual realtor associations that are our owners. And under the rules of those associations, right, they want us to be a member of or follow these NAR rules. So there are no plans whatsoever for CRMLS to change that structure or to not be an NAR affiliated multiple listing service at this point in time.
Oh, okay, well, that's good to know.
Yeah,
All
so the
right.
first assumption in that question was an error. The settlement has nothing to say about whether you're a NAR member or not. It has the settlement deals with there are MLSs that are broker owned that are not owned by associations. And so they have some different paths of what happens in the settlement. But the settlement doesn't deal at all with existing membership with NAR.
Okay, can you cancel a buyer's agreement and redo it with a new fee?
I guess you can. I don't know why you would. So if you go back to the rules, right, as long as you're following these rules, I'm going to warn you guys, though, be careful about losing market share. I've heard all kinds of hyper creative, really neat ideas on how to just have a stranglehold on the old way of doing it. Realize you're probably going to lose the clients because of that. The new way is not hard. It's actually easier. It's simple. It's straightforward. It's easy to understand for consumers. Consumers are going to flock to it. So if you want to really do your best to hold on to the old way, you can, but boy, you're taking some risk. Okay, so I guess you can have an agreement that you can cancel and then set up a new one. One of the things to remember about this rule, the one that's on the screen right now, about the buyer rep agreement. Number one, we as the MLS are going to be enforcing this based on a reporting process, right? And we fully expect people who fail to follow this rule, other agents are going to report you. And so we will prosecute that under our normal compliance process. But there's another aspect here. If you look at the settlement agreement requires, if you look at the definition under the released parties, the settlement agreement requires each individual broker that's getting a release to implement this policy change, to implement this practice change. What that means is, as a broker, if you have agents who are skirting this rule or trying to get around the rule by trickery, right? Like, let's say I enter into one contract at a low number and I see an offer of compensation on a listing at a higher number, so I cancel that first contract and then enter into a second contract. I fully expect a plaintiff lawyer to use that fact to go after your release and argue the release doesn't apply, and you get to be the defendant in the lawsuit and you get to pay full damages, right? So realize at the broker level, if your agents are playing games with this, you risk cutting a massive check because the release will not protect you if you're going to play games with this. You know what, guys? Just sign buyer rep agreement. Every lawyer's been telling you to do this for decades. And in 18 states across the country, this is the norm. In fact, when I talk to some of the members of some of those other states, they actually scratch their head. They're like, why is this even in the settlement agreement? They don't understand. Like, why is this required? We all do this already. So realize lots of people across the country have lived in this world for a long time. Just negotiate your fee with the buyer before you open the door. It's not that hard, right? So I would caution you about entering agreements, canceling them, putting different numbers in. Your broker could end up, losing a release because of that. So,
Okay.
any other questions you want to handle now versus?
No, I just kind of wanted to throw those two out because I think it's important in them understanding the various relationships.
Perfect.
So go on ahead, Ed.
All right, no problem. So again, I think we covered the fact that there'll be no offers of sharing of compensation, in the MLS in any location, right? So I was going on to another requirement of the settlement agreement for us as the MLS. As you know, I'm sure some of you have IDX or VOW websites. And so what the settlement agreement says is that we are not allowed as an MLS to send our listings to a website or facilitate or support any off MLS system where there is still offers of compensation or broker sharing. Okay. So now that means the big portals can't, in essence, replace what the MLS was with regard to offer of compensations. It won't be allowed. We would cut off their data feeds. Now, a couple of exceptions to that. And that is that as to an individual listing broker's own website, you can have offers of compensation on your own listings as long as there are none on any listing that doesn't belong to you. Okay. And in that situation, we'll still give you a data feed, but you have to figure out how to get that information onto your own listing, on your own facilities, and through your own technology. It can't be done at any level through the multiple listing service. Okay. I've seen a lot of third party, hey, come put your listing, your offers of comp in here. Yeah, guys, that's probably not going to fly. That's probably not going to get any kind of marketability. And if it does, I promise you the DOJ will shut that down in about a millisecond. So don't think that there's going to be some big off MLS system created to keep this same element in play, right? And on the screen here is the actual rule that incorporates that policy. Our IDX and VOW rules are contained in Rule 19. And this is where it talks about the fact that you cannot display on your website some other, offers of compensation other than the ones on your own listing. Okay. So that's the kind of the big rules. So realize the way this settlement came about and was structured is that the parties decided that the MLS was going to be the entity that was going to change the rules, enforce the rules. So as a result, there's actually a paragraph that has 13 affirmative things we as an MLS have to do. And we've gone over lots of them already as far as policies, rule changes, technology, elements. Then there's one paragraph, a 14th paragraph, that is the guardrails. And it says these are things you cannot do as an MLS. This was put here to make sure we didn't overstep our authority and get into trouble from an antitrust perspective by making rules that were overly broad or went too far and stepped on people's rights that they have that we don't have the right to limit. And the first of those was that we as an MLS cannot make a rule that prevents a broker from making offers of compensation to buyer brokers off of the multiple listing service. Just like I can't make a rule that says none of you who are members can eat pizza on a Tuesday afternoon, right? I can't make that rule. It has nothing to do with the MLS, right? We cannot make a rule that is so broad that it manages what kind of business you want to do off of the multiple listing service. Okay. I've seen some people take this guardrail exception and try to turn it into like an endorsement that we should all still share compensation. I'm really not sure with these rule changes why you would ever share compensation anymore. It seems like not a great idea. Seems like it's fraught with risk of potential future antitrust liability, and it's also way more complicated than just focusing on the consumer and doing your direct consumer negotiations. Whole lot easier. The other thing that we're not allowed to do again is sellers from offering concessions on the multiple listing service, as long as those concessions are not limited to or conditioned that they can only be used to pay a buyer's agent. Now, concessions are very, very different and distinctive from offers of compensation. In offers of compensation, the only person getting paid was the buyer's agent. That was all you could use the money for, nothing else. And it was locked down. It was from the MLS's perspective, once it went into the MLS, it was now non-negotiable, right? That was what the buyer's agent was entitled to that by rule, by contract. And the parties, the buyer and seller, had nothing to say about that, right? It was locked. So that's very different than a concession. A concession, on the other hand, is an advertisement that a seller says, hey, buyer, to entice you to come to my house. In fact, they're enticing the buyer, not the buyer's agent. I, the seller, will pay for some of your costs. And buyer, I'm going to let you, the buyer, decide how you want to spend those costs. I'm not going to limit it to all the money having to go to your buyer's agent. That's a big distinction, right? So concessions can be used for all kinds of things. And if you look at our what we've done is on May 29th, we actually rolled out a concessions in price field, right? So we are allowing these concessions to happen already. And here's what we discovered, that in 2023, on closed transactions, we monitor concessions that were actually provided in a deal. And we found that 40% of the closed transactions had some kind of form of concession. And when we looked at private remarks, right, the remarks you guys made agent to agent, we found about 15% of those advertised some kind of concession buried in the private remarks. So our thought was, why are these things being buried in private remarks when if 40% of our transactions have concessions happening, shouldn't we let you advertise that in the active listing? And so our new SIP field, concessions in price field, is now live. It is actually supported by the new residential listing agreement that's coming out on June 25th. And I'll show you a slide on how those two things interact. And what you're able to do now when you input a listing is there's a yes, no box, right? Will the seller consider a buyer concession if it was made in the offer? Yes or no? And so you can just select yes or no. The usage of this field to date, it's been live now for a few weeks, is about 60% of the time, agents are just marking the yes no box, right? That's what they're using. They just say, yeah, we'll consider a concession. Yes, we'll consider a concession. No commitment to a number or a dollar amount. About 40% of the time, there is a dollar amount or a percent, which you can also put. Now, remember, a concession is not offer of comp. The buyer gets to decide what they use the concession for, right? The buyer can decide to use all of the concession amount to buy down loan points if they want. That's what the buyer can do. And remember, the concession also has to be put in the offer. And so the concession is subject to negotiation between the buyer and seller. Very, very different than an offer of compensation. Okay. And so, again, over the last 5 years, back in 2019, we had over almost 70,000 closed listings have concessions. By the way, we see concessions even more on entry-level homes. FHA deals in Riverside County in May of 2023, I did this hunt myself. 64% of the closed transactions that had an FHA loan on them offered some kind of concession, and that concession amount averaged 1.8% of the purchase price. So pretty significant amount of concessions and lots of usage of concessions. So now you're going to be able a seller's going to be able to use the concession fields to advertise, to try to encourage a buyer to come to their property. And so this is what it looks like inside of Matrix. It shows up on the basic tab just below list price. And you see there, seller willing to consider a buyer concession if request an offer, yes, no. And then you can put in their dollar amount or a percentage in. And this concept is also now supported by the new CAR residential listing agreement. The form is coming out and is going to go live on June 25th. It is available for you to review and kind of start training on right now. If you go to the CAR website under the proposed forms, these will be coming out. Maybe some people on this call might be part of the forms committee. But paragraph D as in dog, is the one you're going to select if your seller is interested in providing some kind of concession. You mark that box, and then you could check that box yes on the MLS that my seller's willing to do a concession. Or if you want to do a specific dollar amount, you can do that. Not required, right? You don't have to do any of these fields at all. And then but you put that in that chart on paragraph D as in dog. And then you can use paragraph 5 as a little explanation that talks about what concessions are and the different things that can be done for a concession. And remember here, all concessions have to be lumped together, right? So if you have a conversation with your client, the seller, and you're looking like in Riverside County in May of 2023, right? Hey, look, a lot of these closings had up to 1.8% of concessions having nothing to do with paying the buyer's agent, right? So we could see concessions that are considerably more than what people were offering in compensation, right? That is going to be expected. So new field supported by the forms in that capacity. So a great opportunity to do some of that. So a recap of some important dates, right? May 29th, we've already gone live with the concessions and price. June 25th is going to be the CAR form that helps support that with the new RLA. And then on August 13th, that's the important date where no comp fields and the buyer rep agreements have to be done. So for those who, if you want to get more information and really stay super updated in what we're doing, then this is the resource page that you want to go to. We keep this completely updated. We link to a lot of the NAR resources, CAR resources. Art and I have put up some videos. If our training department does some videos, we're going to put those up at this location. If anything happens in the lawsuits, to keep you updated, this is the one-stop shop where you can get all information about what's going on. And I think with that, we're ready to take some questions.
All right. Yes, we have a lot of questions, but I think that most of them were covered in the last couple of minutes when you went over the concession stuff. But there does seem to be a consistent question. Where can you advertise buyer's agent compensation? So can they do that on Showing Time or in a social media platform? Where exactly can they do that?
So I would strongly suggest you talk to your broker and you talk to your antitrust lawyer before doing that first. Second, no on Showing Time. Showing Time is an MLS platform related product. So that is covered by the settlement agreement. We consider that part of the multiple listing service. So if you put it into some kind of comment or showing instruction, we will consider that a violation of the rule. Now, what you do on a social media post or a flyer or something like that is completely up to you. We don't regulate that, as being part of the multiple listing service platform. So at that scenario, that would be okay. Again, with your broker's permission, and I strongly recommend as brokers, you go talk to a seasoned antitrust attorney who understands these cases as to whether or not you should be sharing commissions or not. Keep in mind, guys, that the Department of Justice has won their appeal of a dispute they've been in with NAR since 2019. And that appeal now, the ruling on that, allows the Department of Justice to continue to investigate the antitrust aspects and violations surrounding this commission sharing process. It's not, and remember, that's different than the settlement. The settlement agreement does nothing to hinder or stop the Department of Justice. And in two separate events over the spring, one was in February with an actual paper filing in a case called No Select versus MLS Pin out of Boston, Massachusetts. The Department of Justice wrote down and said the Department of Justice thinks that there should be no offers of compensation anywhere made from a listing broker or seller to a buyer's agent. That was repeated last month when there was a hearing on the same case. The head lawyer for the Department of Justice at a status conference in updating the judge on continued negotiations as they're trying to resolve that case. The DOJ again said the DOJ's position is that brokers should not share compensation and there should be no offers of compensation anywhere, I believe was the exact phrase that they used. So I think that's an important thing to keep in mind. As far as the Department of Justice's point of view, that's not over yet. And so if you're going to think you're going to be advertising offers of compensation publicly out there, and that's still the business plan you're going to do, please just check with your broker to make sure your broker's okay with that. And brokers, check with your antitrust attorneys to make sure you evaluate what the risks are associated with that.
Wow. That was a lot, Ed.
It's an important issue, right?
Yes,
I mean, remember, this is a
an
multi-billion-dollar issue.
Wow. Okay, the other question that seems to be coming up quite a bit, can you explain to us how the open house form works when people go into an open house?
So let me
when do they have to use it? What's it all about? Can you just get into a little more detail on that?
Sure. I'm not going to talk about the form. I'm going to talk about the MLS rules, right? So according to the multiple listing service rules, in that rule about buyer representation agreements, the last sentence of that rule says, nothing in this rule will require any additional obligation or duties on the listing broker. So in the holding of an open house, there is no requirement for there to be anything written down by a buyer or a potential buyer. So here's the concept. When you're the listing broker and any agent in the listing firm, right, you have a contract with the seller directly. And so the seller has given you the permission as the listing broker to let anybody in the house that the listing broker wants, right? Any unrepresented buyer can go through that home with the listing broker or an agent from the listing firm, right? The MLS rules apply only to the cooperating broker, right? A broker representing only a buyer, because that person doesn't have a relationship with the seller. They have no right to be in somebody else's house, right? They derive their rights to enter that property through the MLS rules. And so that's who the rules apply to. So there is no requirement on an open house, or if an unrepresented buyer calls you as a listing agent off of your sign or an internet lead or something, a flyer, you can take them through the house without having to sign anything, right? Because you're representing the seller.
Okay. Wow. You guys have a lot of homework to do out there. All right. What about, and this question keeps coming up, what if I have a contract and it is my listing still in the MLS and this change goes through on August 13th? What do I do?
Right, great question. So a couple things. So realize starting on June 25th, okay, when the new RLA form comes out, right, you can implement doing it the new way without offering compensation if you want, right? Because the form will have a concession if your seller's interested in that. And the way the new residential listing agreement is structured, you can separate your fee so that you only charge what the seller's going to pay you, and you leave 2C2 blank. That's the section on the form that deals with sharing commissions and making an offer of compensation. You don't have to do it. And then when you do a listing input, what you do is you just put 0 in under the comp field today, and you just invite people to put if they need some help in an offer through a concession, right? So you can implement the new way of doing it starting on June 25th. If you do have an existing listing that traverses over, what we're doing on August 13th is if your listing is in a pending status or active under contract, then we are going to leave the commission field in place for that listing so it can go through its regular process. You don't need to do anything. If you have an active listing, hold or withdrawn, right? An unfinalized status listing without a contract, we are going to be removing and purging the offer of compensation field out of your listing. So CAR is actually has already created a form that can be signed to handle this change in the CR Forms library. So CR has created a form that if you're going to have a listing that's not going to go under contract before August 13th, that you can utilize that form to inform the seller of what this change is and modify, and that the listing will be modified and that the offer of compensation will be removed from the MLS.
All right, all right. So I've just got a couple more questions. I think I'm trying to bundle these for you, Ed.
Sure, no problem.
Okay, so what if someone had asked this, and I'm just kind of curious, and I don't even know if you can answer this, but let's just say that there are home builders that have properties that are not in the MLS. How do we deal with the compensation issue with that?
Talk to the builder. It's got nothing to do with the MLS,
Okay.
right? So that really has nothing to do with the MLS. And so you can go straight to the builder, with that and see what their process is. Again, if you're representing a buyer, right, you can certainly include a request for the builder to pay your compensation through the offer, right? You can say, hey, as we make this offer, builder pay Ed Zorn Realty X% of the closing purchase price, right? It
Mhm.
becomes part of the negotiation.
Okay. I think those are the pertinent questions. Someone wanted to know what off MLS means. I'm hoping it's off the subject. So could you please explain that for just 1 second,
Yeah.
Ed?
Off MLS would be a platform or a system not controlled or operated by the multiple listing service. So if you put an advertisement on Facebook, as an example, that's off the MLS, right? If you create a flyer that's sitting in the house's kitchen counter, that's off of the MLS, right? Where things like that, there was that good question about showing time, right? Like, could I put an offer of compensation in the showing time in showing instructions? No, because that's part of the MLS's platform and services that the MLS provides and receives MLS data. So in that environment, these rules would apply, and you cannot make an offer of compensation. Again, I don't know why you would make an offer of compensation, but that's what off MLS means.
Okay, so I think those are the big questions. I see Jeff Kahn is in fact in this forum, and he's saying that there is a form called Disclosure and Modification of Listing Agreement that comes out next week that can be used with current listing agreements, so you will not need to get the whole new listing agreement as of August 14th. And I'm going to take a little bit of time from you, Ed, and I'm going to remind everybody that on July 1st, 15th, and 16th, Jeffrey Kahn will be going over everything new and exciting with all this stuff. So if you have not registered for his classes, I would encourage you to do that. And that will be on Zoom.
Yeah,
Um,
you guys definitely should do that. I got a couple questions I'd like to answer that I saw here that I think
okay.
are super relevant. I'm going to say first off with Jeffrey doing the forms and how the forms interact with the MLS is really important. And so one thing I would like to point out and remind people is that the current residential listing agreement does allow for commission sharing, right? By utilizing the line 2C2. What is really, really important, guys, is that the amount of money put into 2C2 should not be placed in the multiple listing services concession and price field. Sharing commissions, making an offer of compensation is not a seller concession. Okay. It's sharing commissions between brokers. That's how the residential listing agreement is worded. So do not put the amount of money that is in 2C2 on the form into the CIP field. That would be a violation of the MLS rules. And the other thing I wanted to deal with was a question that was asked about first time buyers. Right, there's a lot of concern around first time buyers, individuals that don't have as much money to put down, and there's this thought that how are they going to pay their own agent directly? Right? The answer is they're not going to. They're not. Right? If you've got somebody who's doing an FHA deal, they're only putting 3% down. They probably need even more help to get into the home beyond the payment of their buyer's agent, right? What's going to happen is, as a buyer's agent, what you're going to do, if there's no offer of compensation, is you're just going to put it into the purchase agreement, right? You can write into the purchase agreement, seller to pay, in my case, Edzorn Realty, X% of the purchase price at closing. You can use the SPBB form, right? There's another form out there. It's a little bit more complicated, but you can use the existing form to also request that the seller pay the buyer's agent directly. I think the FHA you're going to find is that the concession field is going to be really great for them because like I said, in one county that I looked at, 1.8% was given from 65% of the closings from the seller to the buyer to help them with other costs above and beyond the buyer broker fee, right? So seeing concessions at 4 and 5 or 6%, very possible. The other thing to remember on the lending is that when you as a buyer's agent and the buyer put into the offer itself that the seller will pay the buyer broker directly, that amount of money does not get used or credited against the interested party contribution limits. So as you know, FHA has, I believe, a 6% limit, right? Fannie Mae has varying limits depending on how much money you're putting down, ranging from 6, I think, to 8 or 9% of interested party contributions, right? This is the contributions that the seller or other parties can make to help pay for some of the costs of the buyer. The buyer broker fee, if it's included in the offer, is not part of that reducing that limit, right? So you can do an FHA loan, put into the agreement, seller to pay Edzorn Realty X%, okay? And I could put another line that says seller to pay buyer non-reoccurring closing costs in the amount of 6% of the purchase price for the buyer's benefit. And we can do both of those things at the same time. And that loan goes through. Right? So there is really no harm or limitation on buyers being able to use the existing ability to use concessions being eaten up by the buyer fee as long as you put it in. Here's the key: you got to put it in the offer, and it's got to be that the seller's paying the buyer agent, right, or buyer broker, right. And if you do it that way, then it's not going to get credited against that IPC cap. Any other questions that you needed me to answer?
Well, I've had a couple people ask about the effect this is going to have on VA loans and all that, but I think you kind of addressed that.
Yeah, let me address VA specifically because there was a little bit more because the VA had a rule that said the veteran can't directly pay their buyer's agent. Well, they don't have to, right? Again, if you put the phrase I said with the VA loan into the agreement, the veteran's not paying the buyer's agent. But just so you're aware, it's my understanding that the VA has actually suspended that rule because of these changes, right? And they're re-looking at modifying that rule. So even that rule is not really in play as we're going to be rolling out, this updated way of handling.
Hmm. Okay, and then let me just see here really quickly. Um, I guess that's about it, unless you can see any other. Oh, here it is. What about verbiage for these compensations that would go into your websites, for example, Zillow, Homes.com, that kind of thing?
Not allowed. None of those platforms are going to have any offers of compensation on them. The moment they do, the MLS that has the listing that has that comp on it will cut the data feed. That's every MLS in the country, by the way. That's a rule that we have being subject to the settlement agreement. So if one of those companies you just mentioned starts to publish offers of compensation on listings that are not their own, we will in about a day turn their feed off and they will lose all listings from CRMLS.
Oh, phew.
So I'm
Okay.
pretty sure that's not going to happen.
Okay. Um, Ed, can you go ahead and put up the slide that had the information for how to
Oh,
reach you and all that? Or
yeah. I will put the resource slide back up
yeah,
in a
thank you
second.
very much. I've had a
Yeah.
couple people ask about that.
Yeah. Let me find this. I don't know why my computer is playing a little funny with me right at the moment.
It's doing it because you've got,
Because we're live on a webinar,
right,
right?
exactly, because you have 500 people waiting.
Right. Yeah, my slideshow doesn't want to reconnect. So
Um,
do it this way. I'll do it this way. Okay. And I will share the screen here.
this was very informative, and I really appreciate the time you've taken to make this presentation to our members and also answer their questions.
Sure. And if there's, I've seen a couple other questions about an amendment to the existing buyer broker agreement. Um, I think what people are getting at is if you sign a buyer broker agreement and then you see some kind of offer of compensation on a property that is more than what you signed the buyer broker agreement for, can you amend the buyer broker agreement? That's an open-ended question. I would talk to your broker and your lawyer first because there's two issues here. One, why would a buyer pay you more? So let me give you the example. Did any of you pay a CPA to do your taxes recently? And if you agreed to pay your CPA $2,000 to do your taxes, and they showed up with your taxes, hopefully before April 15th, and then they handed you a bill for 3,000, are you going to pay that? Like, wait a minute, I hired you to do taxes for $2,000. Why do now you want me to pay you 3,000? And how likely are you to refer that CPA to somebody else? Is that the CPA you want your friends to use? Why would you do that? Right? If I'm a buyer's agent and I agree to represent you to find you a home, and we agree that you'll pay me X, and then we do that, why would I charge you X plus an extra percent? Like, who does that? So I hear people say that, but think that through. That the kind of client that's going to give you a referral in the future? Or are they going to badmouth you to everybody they can find? There's also a legal issue there. If you did no other work, if you didn't add anything to the transaction, right? In other words, you agreed to do work for X, you did that work, now you want X plus an extra percent, there's a concept called consideration, right? That's an amendment to a contract. An amendment requires the same features that a regular contract requires, right? A meeting of the minds and consideration. there's arguably no consideration being given by the agent in that case. You did exactly what you were already obligated to do. You didn't do anything more, right? So I'm not sure that legally that amendment would hold water. That's something I would definitely, consult your legal counsel with to see if such an amendment would actually even be valid. But that is a question that we get quite a lot. I kind of don't understand it, to be honest. I don't know why you think you'd get more money for doing what you agreed to do in the first place. Um, so I think once this process rolls out and it gets going, I think what you'll find is very few people will be, engaging in any of those kinds of tasks. So,
All right. Well, Ed, again, thank you very, very much. Would you be willing to come back again?
of course, as time permits.
Talk about putting someone on the spot. All right. Well, you can look forward to hearing from me again. And I really, again, appreciate your time and effort. Thank you
Right.
so much, Ed.
All right. Thank you.
Bye, everybody.
Bye.